when the system isn't fast enough. There's a question every parent carries in the back of their mind that they never say out loud, because saying it out loud makes it real. The question is this: if someone hurt my child, and the law could not respond quickly enough or did not respond the way I needed it to, what would I do? Most people never have to answer that question. It stays theoretical. A midnight thought, a news story, a worst-case scenario they file away and hope they never open. The four people in today's episode had to answer it in real time, with their hands, with a gun, with a plan they built while the legal system told them to wait. And what they did next and what the law did with what they did is the subject of today's episode. Today's four cases span 40 years in 3 states. They involve 4 different parents, 4 different predators, and 4 very different responses. But they all begin in the same place. A parent discovers that someone has done something to their child that cannot be undone. And from that moment, everything that follows, every decision, every action, every legal consequence flows from the answer to that question. What would you do? The first case is from Louisiana in 1984, and the footage from it has been viewed by millions of people on the internet because a news camera was rolling when it happened. The second case is from Texas in 2020 and involves a father who heard a sound in the middle of the night and walked down a hallway and found something that changed the rest of his life and ended the freedom of a man he had trusted for over a decade. The third case is from Texas in 2014 and involves a former Marine who built his own version of a sting operation in his own living room because the police told him it could take months to build a case. And the fourth case, the one that is still unfolding right now, in early 2026 involves an Arkansas father who woke up to his daughter's dog barking in the early hours of the morning, found her bed empty, got into his truck, and drove into the dark to find her. 4 parents, 4 predators, 4 completely different legal outcomes. And one question that connects all of them. When the law gives you a process and the process feels too slow, at what point does a parent's instinct to protect their child override every other consideration? The legal system has different answers to that question depending on the facts of each specific case. The people in today's episode found out what those answers look like in practice. Before we go into the cases, one framing note. Today's episode deals with child sexual abuse, its occurrence, its legal aftermath, and the actions parents took in response. The details presented are drawn from court records, affidavits, investigative reports, and documented testimony. Nothing is gratuitous. Everything is drawn from the documented record. But you should know going in that this episode goes to difficult places. These are real families and real children in real harm, and they are treated that way throughout. I want to ask you something before we start. All 4 cases today involve a parent who decided that the legal system's timeline was not adequate for the threat their child faced. In 3 of the 4 cases, the parent either was not charged or the charges were ultimately resolved without prison time. In one case, the parent is currently facing a murder charge. As you hear each case, I want you to think about where you draw the line between protection and punishment, between a parent's instinct and the rule of law. Tell me in the comments where that line is for you. Why? Gary, why the airport that changed television? Baton Rouge, Louisiana. March 16, 1984, 9:30 in the evening. The Metropolitan Airport Terminal. A local news crew from WBRZ-TV has been tipped off that tonight a man named Jeffrey Doucette is being escorted back from California by sheriff's deputies, returned to Louisiana to face trial on charges related to the kidnapping and sexual assault of an 11-year-old boy. The news crew sets up their cameras to capture Doucette's arrival. On the other side of the terminal are row of payphones. A man is standing at one of them, talking to his best friend, his back turned to the gate. His name is Gary Plorch. He is 38 years old. He has a .38 caliber revolver in his right boot. Jeffrey Doucette is his son Jody's karate instructor. And what Gary Plorch does in the next 30 seconds is captured on camera, broadcast to Louisiana, and eventually shared with millions of people around the world, one of the most discussed acts of parental vigilantism in American history. The story starts months earlier, in February 1984. Jeff Doucette was 25 years old and ran a karate dojo. He instructed 3 of the Plorch children and had become, as Jody would later describe him, what felt like a trusted figure, someone who was all their best friend. When Doucette told Jody's mother June that he was going to take Jody out for a short drive and would be back in 15 minutes, she had no reason to doubt him. By nightfall, Doucette and Jody were on a bus heading to California. By the time they checked into a motel in Anaheim, just a short walk from Disneyland, Jody Plorch was in the hands of a man who had been grooming him for sexual abuse for more than a year. Jody was gone for 10 days. His parents did not know where he was. Then he was allowed to call his mother from the motel. Police traced the call and located the motel. Doucette was arrested. Jody was put on a plane back to Louisiana. The sexual assault examination conducted after Jody's return confirmed that the abuse had continued during the trip. Doucette was extradited to face trial. And a Baton Rouge sheriff's major who was a personal friend of Gary Plorch made a decision to inform him directly about what Doucette had done to his son. According to the sheriff's major, Gary Plorch had what he described as the same reaction most parents have when they find out their child has been abused. He was horrified. But Gary Plorch also said something, to multiple people, that his son Jody later said was the reason he had never been able to tell anyone what was happening to him. Gary Plorch was not a quiet man about his feelings. He told people explicitly, "If anybody ever touches my kid, I will kill him." Jody had heard it. Jody had believed it. And so when the abuse began, when it felt wrong and confusing and impossible to name, Jody said nothing to his father, because he knew. The airport, an employee of the WBRZ news crew, told Gary Plorch what flight Doucette would be on and when he would arrive. Gary told his son Mikey he was going out to dinner. He went to the airport instead. He positioned himself at the bank of payphones with his back to the arrivals area. He called his best friend Jimmy. According to what Gary later said, he told Jimmy as he stood there, "Here he comes. You're about to hear a shot." The WBRZ camera was rolling when Doucette walked past a news crew, handcuffed, flanked by sheriff's deputies. He walked past Gary Plorch at the payphones. Gary turned. He fired one shot into the right side of Doucette's head from 3 feet away. He lowered the gun. He turned back to the phones and hung up the receiver. Deputies immediately grabbed Gary Plorch and pressed him against the phones. One of the deputies knew him. The audio captured on the news camera records a deputy asking over and over in a voice that carries both law enforcement urgency and something that sounds like genuine grief. "Why, Gary? Why? Why, Gary, why?" Gary Plorch gave the answer. That will become the most quoted thing he ever said. "If somebody did it to your kid, you'd do it too." Jeff Doucette fell into a coma and died in the hospital the following morning. Gary Plorch was initially charged with second-degree murder. What happened next in a 1985 courtroom is what made this case a permanent part of legal and cultural history. Defense psychiatrist Dr. Edward Puzzi examined Gary Plorch and determined that at the moment of the shooting, he had entered a state in which he could not distinguish right from wrong, a temporary dissociation driven by the accumulated trauma of what had been done to his son. Defense attorneys argued there was no risk he would ever commit another crime, because the only thing that could produce this specific act was a specific knowledge of what had been done to his specific child. Judge Frankside agreed. He ruled that sending Gary Plorch to prison would not help anyone, not the community, not the victim's family, not Gary Plorch himself. Gary Plorch pleaded no contest to manslaughter. He received a 7-year suspended sentence, 5 years of probation, and 300 hours of community service. No prison time. He spent a single weekend in custody. He went home. Jody Plorch was angry at his father when he found out. He was 11 years old and had seen Doucette as a friend, someone whose abuse, in the way that grooming works, had been carefully constructed to feel like something other than what it was. He said, years later, "I didn't want him dead. I just wanted him to stop." Jody went on to become a sexual abuse awareness activist, speaking at universities and working at victim services centers. He wrote a book about his experience, titled Why, Gary, Why? The Words the Deputy Cried at the Airport. In 2024, Jody said he regarded his father as the greatest dad of all time. Gary Plorch died in 2014 following a stroke at age 68. He maintained until his death that he had no regrets. What do you think the difference is between what Gary Plorch did and what justice is supposed to do? Tell me in the comments. Gary Plorch waited by payphones in an airport with a gun in his boot and shot Jeff Doucette in the head while a news camera rolled. He received no prison time. His son became an advocate for other victims of sexual abuse. The case is 40 years old and is still among the most watched and most discussed examples of parental protection in American legal history. The question it raises about when a parent's action however illegal in form, is treated by a court as understandable in substance, is not a question the legal system has ever fully answered. It handles it case by case. And the case-by-case answers look very different from each other, as the next 3 cases will show. The sound in the hallway. A father holds the line. Rockwall, Texas, January 12, 2020. A Sunday night. A father is asleep in his home. His longtime friend Mark Miller, 35 years old, is staying overnight in the living room. A man this father has known for more than a decade, a man he has trusted without reservation for years. The father hears a noise. He gets up to check. He notices that Miller is not in the living room where he has been sleeping. And he knows, with a certainty that is not a thought but a physical sensation, that something is wrong. He walks to his daughter's bedroom. He opens the door. What he finds on the floor of that room, in the middle of the night in his own home, is a thing that the next 3 years of his life and the rest of Mark Miller's life will be built around. He does not lose his mind. He does not reach for his phone. He reaches for his gun. The father held Mark Miller at gunpoint until Rockwall County deputies arrived at the residence. That is a sentence in the official documentation. It is a sentence that describes a period of time, however long it took for the deputies to respond to the call that the child's mother had just made, during which this father stood in his daughter's bedroom with a weapon trained on a man he had trusted as a friend for more than 10 years, in the room where his daughter had just been assaulted, and did not pull the trigger. What the investigation that followed revealed was that the abuse had not begun that night. Mark Miller had been sexually abusing the child since she was 7 years old. 2 full years of sustained abuse that had been taking place inside the home of his best friend, under the cover of a friendship and a trust that Miller had spent years building and exploiting. He had not been a stranger. He had not been someone the family had met recently or had reason to be cautious about. He had been, by the father's own account, someone he trusted completely, a man he had known for over a decade, a man the family had welcomed into their home without hesitation. What the investigation found. When Rockwall County Sheriff's deputies arrived and took Miller into custody, Miller admitted immediately that he had been molesting the child for years. His description of their relationship, according to the court documentation, was that it had been, in his words, a little too close. That is a phrase a man uses when he is trying to minimize, in front of law enforcement, something for which minimization is not available. The forensic examination of Miller's electronic devices that followed produced evidence that extended far beyond the abuse of this one child. Rockwall Police Department Detective Philip Young documented what was on Miller's computers and cell phone, videos Miller had filmed of himself abusing the child. Not 1, not 2, at least 5 videos, with 132 images, covering the period from when the victim was 7 years old. Miller had set those videos to play on a virtual reality headset. He had used an image of the child as his computer screensaver, a detail that appears in every major account of this case because it encapsulates, in one specific and disturbing fact, the nature of what was actually happening in that man's mind. Further forensic analysis of Miller's devices revealed more than 8,000 additional sexually explicit images of other children. The abuse of this family's daughter was not a unique obsession. It was part of a broader pattern of behavior that Miller had been concealing behind the friendship that gave him access. Rockwall County District Attorney Kenda Culpepper described the case as disturbing on so many levels. She said it underscored that no community is immune from sexual predators, and that remaining vigilant to keep children safe from such evil was a responsibility that extended beyond law enforcement. Rockwall County Assistant District Attorney Justin Armand said, with precision, that Mark Miller uses undeserved trust to torture this little girl. Undeserved trust. That phrase describes exactly what Miller had done, not just a physical harm, but the specific category of violation that comes from exploiting the trust of people who had loved him as a member of their extended family. The sentences. Mark Miller was arrested on January 12, 2020. The federal case moved first. Miller was indicted in June 2020 on charges of producing child pornography. In March 2022, he pleaded guilty to 2 federal counts. On September 8, 2022, United States District Judge Jane J. Boyle sentenced him to 60 years in federal prison, the statutory maximum available under the law. 60 years. At 35 years old, that is a sentence that means the rest of his life. The state case followed. On January 5, 2023, 439 Judicial District Court Judge David Rakow sentenced Miller on 2 counts of aggravated sexual assault of a child, to which he had pleaded guilty to life in prison. Life in prison, to be served concurrently with a 60-year federal sentence. The combined legal outcome: Miller will spend every remaining day of his life in prison for what he did in that bedroom and in the 2 years that preceded it. The father who held Mark Miller at gunpoint that night in January 2020 is not publicly identified in any of the court documents. Neither is his daughter. That is appropriate and necessary. The child was 9 years old at the time of the arrest. She was 7 when the abuse began. She had been victimized for 2 years before her father walked down that hallway and heard a noise and opened that door. What she carries from that experience is not something a court record can fully document. What her father carries, from the moment he found them in that bedroom and made the decision to hold rather than shoot, is not something a press release can adequately describe. But the father did hold. He did not fire. He held Miller at gunpoint, called the deputies, and handed the case to the legal system. And the legal system, in this instance, delivered 2 sentences, one federal and one state, that will keep Mark Miller incarcerated for the rest of his natural life. That is what the legal system can do when it has the evidence and the authority to act. What it required, in this case, was a father who heard a sound in the hallway at night and did what had to be done to get Miller into custody and the evidence into court. The father in the Rockwall case held his friend at gunpoint for however long it took the deputies to arrive, and then he handed the case to the law. Mark Miller got life in federal prison plus a life state sentence. The child got justice through the system, not through her father's gun. When you compare this outcome to the Gary Plorch case, where the father shot and received no prison time, what does a difference tell you about the choices parents make in these situations and what those choices cost them? Tell me in the comments. A man trusted for more than a decade of friendship that was a decade of access. A father who heard a sound and walked down a hallway and found what was there and made a decision that cost him the friendship and cost Mark Miller everything. 60 years federal, life in state prison. Concurrent, Miller will die behind bars. The child he abused starting at age 7 has a record in a judge's sentence that says what was done to her was seen, was named, and was responded to with the full weight of the law. That is what this father's decision to hold rather than shoot made possible. The ex-Marine who ran his own sting. Lorena, Texas, 2014. Brandon Moore, a former United States Marine, goes to the emergency room. He is admitted for what doctors suspect may be an aneurysm. While he is in the hospital, a neighbor named Sean Foster, a man who runs a pool company, a man who had befriended the Moore family, a man who had offered to help around the house and had built enough trust to employ Brandon's 14-year-old daughter Madeline doing work for his company, drives to the Moore home. Madeline is there, asleep, and Sean Foster, aware that Brandon is in the hospital and not at home, molests his daughter in her bed. 2 days later, still recovering, Brandon Moore learns what happened. He and his wife Leone do what parents are supposed to do. They call the police. The police tell them it could take months to build a case. Sean Foster remains free. And Brandon Moore, a former Marine, decides that he is not going to wait months. Brandon and Leone had no idea how long the abuse had been going on. During Foster's eventual trial, they would learn things they had not known. That Foster had groomed Madeline systematically, over time, buying her gifts, rings, a cocktail dress, things that were stored at Foster's home specifically so her parents would not see them. That he had employed her at the pool company in part because it gave him access to her. That when he drove her to a medical appointment and told the nurse he wanted to accompany the 14-year-old girl into the exam room, and threw what the nurse described as a tantrum when she was refused, it was because he did not want the exam to produce evidence. That the night he went to the Moore home while Brandon was in the emergency room, he had chosen that window specifically because he knew Brandon would not be there. Foster had been a neighbor, then a family friend, then an employer to their daughter. He had, in Brandon's words, really manipulated me and my wife. Brandon later said, through tears, "I'm embarrassed and ashamed to say that, and it's really made me wary of trusting anybody again." That is what grooming does to the adults around the victim. It does not just isolate the child. It builds a structure of trust and normalcy that makes the adults feel, in retrospect, that they should have seen it coming and did not. They could not have seen it. That is the point of the structure. The sting. The police told Brandon Moore the investigation could take months. They explained, As a Lorena Police Chief Tom Dixon would later confirm, that in cases like this one, if you do not do your homework, the suspect could walk free. That is a real concern. Investigative timelines in child abuse cases exist for sound procedural reasons. But Brandon Moore was a former Marine whose daughter had been assaulted in her own bed while he was lying in a hospital. He was not interested in months. He built a plan. He took Madeline's phone and texted Foster, posing as his daughter. He wrote that she was still in the shower and asked Foster to come pick her up for work in 15 minutes. Then he went inside the house, locked the front door, turned on the shower so the sound would be audible from outside, and sat in a darkened room. He waited. Foster received the text. He called the phone first to confirm, as Brandon understood it, that Brandon was not home. Then he drove over. He did not knock on the front door. He did not honk in the driveway and wait to be let in. He tried the locked front door, found it locked, and found another way in. Brandon Moore later said, if he wasn't a creep or a jerk, he would have pulled into the driveway and honked or knocked on the door. Foster's decision to enter a locked home rather than knock is a documented fact that was presented to a jury. The audio of what happened next, when Foster found Brandon Moore waiting in the dark rather than a 14-year-old girl, was recorded and preserved. Brandon Moore's own account, I beat him up pretty bad. By the time police arrived, his foot was swelling from kicking Foster. Moore was investigated for assault. The Lorena police chief later said the department certainly did not recommend what Moore had done, that under high emotions people do not always make the best judgment calls, and that the situation could easily have become a homicide or an aggravated assault charge against Moore. But Moore was not charged. The ex-Marine who ran his own sting. Lorena, Texas, 2014. Brandon Moore, a former United States Marine, goes to the emergency room. He is admitted for what doctors suspect may be an aneurysm. While he is in the hospital, a neighbor named Sean Foster, a man who runs a pool company, a man who had befriended the Moore family, a man who had offered to help around the house and had built enough trust to employ Brandon's 14-year-old daughter Madeline doing work for his company, drives to the Moore home. Madeline is there, asleep, and Sean Foster, aware that Brandon is in the hospital and not at home, molests his daughter in her bed. 2 days later, still recovering, Brandon Moore learns what happened. He and his wife Leone do what parents are supposed to do. They call the police. The police tell them it could take months to build a case. Sean Foster remained free, and Brandon Moore, a former Marine, decides that he is not going to wait months. Brandon and Leone had no idea how long the abuse had been going on. During Foster's eventual trial, they would learn things they had not known, that Foster had groomed Madeline systematically, over time, buying her gifts, rings, a cocktail dress, things that were stored at Foster's home specifically so her parents would not see them, that he had employed her at the pool company in part because it gave him access to her, that when he drove her to a medical appointment and told the nurse he wanted to accompany the 14-year-old girl into the exam room and threw what the nurse described as a tantrum when she was refused, it was because he did not want the exam to produce evidence. That the night he went to the Moore home while Brandon was in the emergency room, he had chosen that window specifically because he knew Brandon would not be there. Foster had been a neighbor, then a family friend, then an employer to their daughter. He had, in Brandon's words, really manipulated me and my wife. Brandon later said, through tears, I'm embarrassed and ashamed to say that, and it's really made me wary of trusting anybody again. That is what grooming does to the adults around the victim. It does not just isolate the child. It builds a structure of trust and normalcy that makes the adults feel, in retrospect, that they should have seen it coming and did not. They could not have seen it. That is the point of the structure. The sting. The police told Brandon Moore the investigation could take months. They explained, as the Lorena Police Chief Tom Dixon would later confirm, that in cases like this one, if you do not do your homework, the suspect could walk free. That is a real concern. Investigative timelines in child abuse cases exist for sound procedural reasons. But Brandon Moore was a former Marine whose daughter had been assaulted in her own bed while he was lying in a hospital. He was not interested in months. He built a plan. He took Madeline's phone and texted Foster, posing as his daughter. He wrote that she was still in the shower and asked Foster to come pick her up for work in 15 minutes. Then he went inside the house, locked the front door, turned on the shower so the sound would be audible from outside, and sat in a darkened room. He waited. Foster received the text. He called the phone first to confirm, as Brandon understood it, that Brandon was not home. Then he drove over. He did not knock on the front door. He did not honk in the driveway and wait to be let in. He tried the locked front door, found it locked, and found another way in. Brandon Moore later said, if he wasn't a creep or a jerk, he would have pulled into the driveway and honked or knocked on the door. Foster's decision to enter a locked home rather than knock is a documented fact that was presented to a jury. The audio of what happened next, when Foster found Brandon Moore waiting in the dark rather than a 14-year-old girl, was recorded and preserved. Brandon Moore's own account, I beat him up pretty bad. By the time police arrived, his foot was swelling from kicking Foster. Moore was investigated for assault. The Lorena police chief later said the department certainly did not recommend what Moore had done, that under high emotions people do not always make the best judgment calls, and that the situation could easily have become a homicide or an aggravated assault charge against Moore. But Moore was not charged. The trial in Sean Foster. The audio recording of Brandon Moore confronting Sean Foster in the darkened house was played for the jury at trial. Madeline Moore testified, with a fever of 101 degrees, with strep throat, with a bucket on the floor beside the witness stand in case she became sick, in a courtroom where her abuser was sitting across from her. She told him directly, in her victim impact statement, "You can't hurt me anymore." She was 16 years old at the time of the trial. The jury deliberated and returned a verdict against Sean Foster on 6 charges: burglary of a habitation, 3 counts of indecency with a child by contact, and 2 counts of indecency with a child by exposure. They sentenced him to 55 years in prison. They also fined him $40,000. Police Chief Tom Dixon told Brandon Moore after the verdict that his actions in running the sting had a dramatic effect on the speed of the case. That the moment Foster broke into the locked house, the investigation that could have taken months was over in a night. He said the jurors almost certainly took Foster's behavior that night into account when they deliberated. The evidence Moore had collected by waiting in the dark with his daughter's phone, Foster's action in entering rather than knocking, became part of the trial. Madeline Moore asked, years later, to be publicly identified by name. She said, "This happens a lot more than we think it does." She said she wanted to use her experience to help others. She said she would encourage parents to really talk to their kids seriously about it. Brandon Moore, speaking about watching his daughter testify, said she was his new hero. His voice broke as he said it. "She's amazing." Brandon Moore ran his own sting because the legal system told him it could take months, and he made a different calculation. He was investigated for assault and not charged. Foster got 55 years. Madeline Moore chose to be publicly identified and use her story to help others. When you think about what Brandon Moore did, not a shooting, not a killing, but a decision to not wait for a system that had told him it needed time, where does that fall for you on the spectrum of what a parent is justified in doing? Drop your answer in the comments. Brandon Moore turned on a shower and sat in the dark with his daughter's phone and waited for the man who had hurt her to make the decision that would define the rest of his life. Sean Foster made that decision. He chose not to knock. 55 years. Madeline Moore, sitting in a witness stand with strep throat and a bucket on the floor, told her abuser he could not hurt her anymore. The case that could have taken months was resolved in a night because a former Marine decided he was not going to wait. His foot was swollen from kicking. He was not charged. His daughter asked to be named because she wanted her experience to mean something to someone else. That is what came out of one night in Lorena, Texas, when a father chose not to wait. Just after midnight, the case that is still happening. Lonoke County, Arkansas, just after 1 in the morning. October 8, 2024. Aaron Spencer, 37 years old, Army veteran, farmer, is asleep in his home. His daughter's chihuahua starts barking. He goes to her room to check. She appears to be asleep, tucked under the covers. He looks more closely. It is a stuffed animal, wrapped in her hoodie. His 14-year-old daughter is gone. Aaron Spencer's family has been on edge for months. 4 months earlier, their daughter, then 13, had told them that she had been sexually abused by a 6 to 7-year-old man she had met at the home of a family friend. That man's name was Michael Fosler. Fosler had been arrested. He had been charged with 43 criminal counts: internet stalking of a child, sexual assault, sexual indecency with a child, possession of child pornography, all of it related to Spencer's daughter. He had pleaded not guilty and had been released on a $50,000 bond, with a no-contact order that specifically prohibited any contact with any minor. His trial was scheduled to begin in 3 months. Spencer's daughter was the only witness. Aaron Spencer got into his truck and started driving. He called 911 just after 1 a.m. to report his daughter missing. The Lonoke County Sheriff's Office contacted Cabot Police to check a specific address. Before they had confirmed anything, Spencer was already moving through the dark roads of Lonoke County. He spotted what he recognized as Fosler's white Ford F-150 on Highway 236, driving in the direction of Fosler's home. His daughter was visible in the passenger seat. Spencer made a U-turn. He began following Fosler's truck, honking and flashing his headlights. He followed for approximately 6 miles. At the intersection of Highway 236 East and Highway 13 North, Spencer rammed his truck into the rear of Fosler's, sending the F-150 into a ditch. He exited his truck with his weapon in hand. He saw his daughter trying to exit the passenger side. He told investigators that Fosler grabbed her and stopped her from getting out. He ordered Fosler out of the vehicle. According to the arrest affidavit, Fosler exited with something in his hand and lunged toward Spencer, saying 2 words. Spencer fired 16 shots. 15 of them struck Michael Fosler. Spencer then jumped on him and pistol-whipped him with the empty weapon. He reloaded. He helped his daughter out of the truck. He called 911 at 1:34 a.m. 22 minutes after his wife's first call. He told the dispatcher, "Michael Fosler is dead on the side of the road for trying to kidnap my daughter. I had no choice." The charge. Lonoke County Sheriff John Staley oversaw Spencer's arrest. He said publicly that he did not think Aaron Spencer was a bad person, and that he believed Spencer was genuinely trying to protect his child. But he also said something else. He said, "We live in a nation of law and order. If we let that mindset, even when anger is understandable, replace the rule of law, we get anarchy. That's not who we are." Aaron Spencer was charged with second-degree murder, which in Arkansas carries a maximum sentence of 30 years. He also faces a firearm enhancement penalty that can increase that sentence if he is convicted. His attorneys do not deny that he shot and killed Michael Fosler. They argue that he acted within the law to protect his daughter from a man who was kidnapping her, who had already committed dozens of documented crimes against her, and who Spencer's attorney Aaron Casanelli argued. His daughter was the only witness against in a trial that was 3 months away. Casanelli said, at that time, she was the only thing standing between him and life in prison. The prosecution has a different account. Prosecuting attorney Chuck Graham argues that Spencer had options he chose not to use, that he could have called police while following Fosler's truck. Evidence from July 2024, when Spencer had gone looking for Fosler's address months before the shooting and explicitly asked a witness not to call police, suggests the prosecution plans to argue this was premeditated rather than reactive. Graham described 16 shots and a pistol whipping as exceeding what self-defense law permits, even given everything Fosler had done. He told reporters, "Do you really want to live in a society where people just go and kill somebody? Like the Wild West? That's not how we operate." The Arkansas Supreme Court, in a 2025 ruling related to a gag order that had been placed on the case, removed the presiding judge at the request of Spencer's defense and appointed retired Circuit Judge Raul Wilson to oversee the trial. A pre-trial hearing was scheduled for March 2026. The trial had not yet begun as of early March 2026. Spencer is out on bond. The sheriff's race. While awaiting trial for second-degree murder, Aaron Spencer filed paperwork to run for Lonoke County Sheriff, the office held by the man who arrested him. His campaign platform is built around the argument that the system that failed to adequately protect his daughter from Michael Fosler, a man who had been arrested and charged with 43 counts and released on a $50,000 bond that Spencer argued was far too low, needs to change from the inside. In an announcement video, Spencer said, "Through my own fight for justice, I have seen firsthand the failures of law enforcement, and in our circuit court." He described himself as a father who had no interest in politics before what happened to his daughter, and who now believed he was called to change a system that had failed his family and would fail others. On March 3rd, 2026, 4 days ago, Aaron Spencer won the Republican primary election for Lonoke County Sheriff. He won more than 53% of the vote. He defeated John Staley, the incumbent sheriff whose department arrested him in 2024. Sheriff Staley conceded the race. Prosecuting attorney Graham, who is still pursuing the murder case against Spencer, told reporters, We were in the process of it, and I think we were going to convict Fosler. He said not everything the public has heard about the case is accurate, and that what will be laid out at trial is different from the public narrative. He said, "We don't live in the Wild West. But in this office and all around Arkansas, the prosecutors just follow the law, no matter what public opinion is. If Aaron Spencer is convicted of second-degree murder before the November general election, he will be unable to serve as sheriff. His trial date has not yet been set. He continues to campaign. The case continues. 4 days ago, Aaron Spencer, who is charged with murder, who fired 16 shots at a man who had been charged with 43 crimes against his daughter, and who Spencer says were preventing her from leaving his vehicle in the middle of the night, defeated the incumbent sheriff in a Republican primary by more than 53% of the vote. The community of Lonoke County, Arkansas, made that decision. What does that vote tell you about where the community draws a line between what the law says and what they believe a father was justified in doing? And does a community's judgment change anything about what the court should do? Tell me what you think." Aaron Spencer woke up at 1 in the morning to a chihuahua barking, found a stuffed animal where his daughter should have been, drove into the dark, found her in a truck with a man who had 43 criminal charges against him and a no-contact order he was violating, rammed that truck into a ditch, and fired 16 shots. He is charged with second-degree murder. He is out on bond. He is running for sheriff. He won the primary. His trial has not yet started. Michael Fosler is dead. Spencer's daughter is alive. Everything else about this case, whether what Spencer did with protection or punishment, whether it was justified or criminal, whether communities vote for a man facing a murder charge is a statement about justice or a statement about something else entirely, is still being decided. In court, and at the ballot box. The line the law draws and the line parents draw. 4 cases, 40 years. Gary Plorch in 1984, waiting by payphones with a gun in his boot, filming the moment on a news camera that still circulates. A father in Rockwall, Texas in 2020, walking down a hallway in the middle of the night and holding a man at gunpoint until the deputies arrived. Brandon Moore in Lorena, Texas in 2014, sitting in a darkened room waiting for the man who had assaulted his daughter to come through a door and prove, by his own action, that he was exactly what Brandon believed him to be. And Aaron Spencer in Lonoke County, Arkansas in 2024, driving into the dark at 1 in the morning with his daughter's empty bed behind him and a truck he recognized ahead of him. These 4 cases involve 4 different decisions. Gary Plorch decided to execute, in public, in front of cameras, on the day his son's abuser was being returned by law enforcement to face trial, the same trial that would have produced a sentence, that might have produced a conviction, that the legal system was in the process of delivering. The Rockwall father decided to hold and let the system work. And the system worked. Brandon Moore decided to run his own investigation when the system told him it needed more time, and then let the system take over from there, and the system worked. Aaron Spencer decided, in the middle of the night, that a man who had violated his daughter 43 times and was now in a truck with her had no right to the protection of a legal process that Spencer did not trust to move fast enough. And what the system is now deciding is whether that decision was self-defense or murder. The legal outcomes across these 4 cases are strikingly different from each other. Gary Plorch, a suspended sentence, 5 years of probation, no prison time. The Rockwall father, no charges, a predator serving a life sentence plus 60 years. Brandon Moore, no charges filed, a predator serving 55 years. Aaron Spencer, charged with second-degree murder, awaiting trial, facing up to 30 years of convicted, simultaneously winning a sheriff's primary election. The difference between the first 3 outcomes and the 4th is not obviously about the severity of what the predator had done. Michael Fosler had been charged with 43 counts. Jeff Doucette had kidnapped and assaulted an 11-year-old. Mark Miller had abused a 7-year-old for 2 years and filmed it. Sean Foster had groomed a 14-year-old systematically for years. In terms of the scale of harm inflicted on the child, all 4 cases are devastating. The difference in the legal outcome for the parent appears to lie in what the specific facts of the action were, the location, the timing, the number of shots, whether the threat was ongoing at the precise moment force was used, and what investigators and prosecutors believe they can prove about the parent intent at the moment of the act. Gary Plorch shot Doucette in public, at an airport, surrounded by deputies and cameras, on a day when Doucette was in custody, not actively posing a threat to Jody. The defense argument about temporary psychosis carried the day. The Rockwall father held a gun and called the police. He used force to detain, not to kill. Brandon Moore used physical force, which is categorically different from lethal force, and it created the conditions under which Foster's own actions became the key evidence. Aaron Spencer fired 16 shots and pistol-whipped a man. The prosecution says he could have called 911 while following the truck. The defense says his daughter was being grabbed, that Foster was lunging, that there was no time and no other choice. Who is right about what happened at that intersection on Highway 236 in the dark at 1:34 in the morning is what a jury in Lonoke County, Arkansas, is going to have to decide. That jury has not yet been assembled. The trial date has not yet been set. Aaron Spencer is currently the Republican nominee for sheriff of the county where he is charged with murder. Whatever that jury decides, it will produce a verdict that many people in Lonoke County will either celebrate or challenge, because the community has already weighed in on what it thinks should happen, and the result was a 53% primary victory. What these cases ask. Every one of today's 4 cases asks the same question. Where is the line between what the law permits and what a parent believes they must do? The law's answer is precise and case-specific. It involves the legal definitions of self-defense and defense of others, the presence of an imminent threat, the proportionality of the response, and the evidence available at the moment of the act. It is a framework built over centuries of legal development specifically to handle the fact that human beings sometimes act in states of extreme emotion in situations where the ordinary rules of behavior do not feel adequate. The parent's answer is different. It is in the sound of a dog barking at 1 in the morning, in a stuffed animal tucked under a hoodie where a daughter should be, in the moment of walking down a hallway and opening a door, in the knowledge that the person doing this harm is never going to stop on their own. The parent's answer is not a legal framework. It is a thing that exists before law, in the place where the law's frameworks were built to manage. It is a protection of a child, at whatever cost. Today's 4 cases show you 4 versions of what that protection looks like, and what the law did with each of them. In 3 cases, the parent was not imprisoned. In 1, the question is still open. What you think about each, what you would have done, where you believe the line is, whether the outcomes feel like justice is what I want you to carry into the comments. These cases do not end in the courtroom. They end in the conversation communities of afterward about what we expect from the law, what we expect from parents, and what we are willing to call justified when a child has been hurt. If this episode stayed with you, if one of these 4 cases is the one you cannot stop thinking about, tell me which one and why. These families are real. The children in these cases are real. Gary Plorch is buried in Louisiana. Jody Plorch is a sexual abuse awareness activist who says his father was the greatest dad of all time. A 9-year-old girl in Rockwall, Texas grew up knowing that her father walked down a hallway in the dark and held the line. Madeline Moore sat in a witness box with a fever and told the man who hurt her that he could not hurt her anymore. And Aaron Spencer's daughter is alive, and her father just won a Republican primary, and his trial has not started yet. See you in the next one.